First, why art? Because as human beings, we have more in common than we have difference. And in today's global economy and international legal world, it is imperative that everyone understand one another and learn from another's culture. And the first step to understanding one another is to be able to empathize, and art is a method by which this can be accomplished. Last spring break, I had the good fortune of meeting Lucille Roussane at the American Society for International Law, ASIL, and one of the patrons is Benjamin Ferencz. And he, at 27 years old, was the chief prosecutor at the Nuremberg trials, and one of the instrumental people that created the International Criminal Court. And one of his favorite quotes of mine is, "Never stop trying to make it a more humane world. Just try." That is what I ask others to do, to try. And if we work together, I am confident that this will come about. And this is Benjamin Ferencz at 27 years old, the chief prosecutor for the Nuremberg World Trials. And the sidebar for the law students here, and for those of us joining on live stream, Mr. Ferencz was 27 years old when he convicted Nazis of the worst atrocities against humanity. And he was 27 years old when he made this impact on the international community. And here at Hofstra, our mission statement is to make an impact. This is a picture of Mr. Ferencz, General Dwight D. Eisenhower, and General Omar Bradley discovering art looted by the Nazis. And I am pleased to say that Hofstra next year will be working with the Cardozo Art Law Society as well as ASIL to put on a 2-day conference on restitution of art held at the Cardozo School of Law in Manhattan.
And so what I'd like to do is to address a real problem of how to approach ownership, title, obligations of players of cultural property in the context of indigenous peoples. The first thing that I'd like to say is that what does this include? Well, I think this includes visual arts, paintings, murals, sculptures, friezes, crafts, jewelry, clothes, tools, objects, and even intangible property and performing arts, dance, music, etc. And I guess the core issue as I see it as an outsider is should this artistic property involving indigenous peoples be treated the same as any other art? Or does it require different treatment? This is an unresolved question, and we can't solve it today, but maybe we can frame a couple of the issues that are lively, at least from my perspective. As I see it, a couple of strands come into play. First, what is the broad traditional property law framework that operates in art markets? And secondly, is indigenous peoples' art any different from other art that compels a deviation or different treatment than the traditional property model in art markets? And here I primarily address the intrusion of international human rights law and notions of the existence of collective international human rights into the equation. There are other issues, to be sure, involving this question, but I would like to stick to the relevance of international human rights law and the traditional property model in art markets.
Not only do I agree with you, but the art market is the only market in which extremely valuable property is totally uncontrolled by any rights that are confirmed by contract. There is no such thing, as a title search to art. You can live in a $300,000 house and absolutely know you own it because you've got title and you've got title insurance. But the $100 million Monet above the fireplace, it may be yours and it may not be yours. It kind of depends on its history. What is art law? It's really a many-faceted field of the law, and some of it, is concerned with writing contracts for museums, for dealers, for artists, and then there's the more exciting part of it. I have a very good friend who sits on the art law committee of the New York City Bar with me, who is not an art lawyer. She, in fact, does hospital law, health law, but she is an artist, and she joined the art law committee because she said she thought it would be about art. And now 3 years later, she finds it's not about art at all. It's about nothing but crime. So there are a number of federal laws in place that are applicable in international and national cases involving artworks. The National Stolen Property Act, which was, I think, originally enacted for drug lords, but comes in really handy when you have artworks that pass through the control of several countries or even states. If you transfer a looted painting from New York to Chicago, you have violated the National Stolen Property Act unless you can prove you own it. The Archaeological Resources Protection Act basically refers to the protection of federal lands and Native American lands. The Cultural Property Implementation Act is quite specific in that it requires countries who want their antiquities protected under U.S. law to apply to the Cultural Property Advisory Commission and to enter into a bilateral agreement with the United States that will protect a specific category of antiquities. A lot of the dealers think the categories are much too broad, but fortunately they are what they are. Then there's, of course, there's customs, which is the first bulwark of protection, now called ICE, which I can never remember. It's Immigration, Customs, and something. Many of them have been trained by art historians and art lawyers. They know what they're looking for. They're very, very good, at least in New York and major ports. And you can import any art into the United States, but you must declare it and declare it honestly. And that's where some people have gotten into major trouble. A dealer in New York who worked with a dealer in England, and they both worked with thieves in Egypt. They used to get the antiquities and tart them up, paint them garishly to show that they're just tourist things, and then they'd get them into good old Fred's workshop in New York, take the garbage off and offer them for sale. The Schultz case was U.S. v. Schultz. It's one of the few cases that actually was a criminal law case, and Fred was convicted and spent 3 years in Club Fed. The Visual Artists' Rights Act applies much more to the makers of art than the buyers of art. And in New York State, we have the Art and Cultural Affairs Statute, which provides broad protection to both artists and purchasers.